92. The current information regarding the defendant is that he is no longer expressing adherence to the United Kingdom of Australia philosophy. This should be seen at least some evidence of decreased risk, regardless of the caution expressed by the treating specialists that he may be stating this to deflect scrutiny. So Justice is pointing out something while pointing out these international criminal offences that are taking place, in that the defendant had already proclaimed that he didn't want to be drugged, and they did it by force anyway. And then when he complained about that, they upped the dosage, and then tried to present him while drugged as being that as his initial state, and then decided they couldn't do that, would do it on paper reports instead, and come to a conclusion that was totally fabricated from initial attacks by Fixated Persons Unit, at which Matthew Reason admits to taking command of for these specific attacks. The court is pointing out to the police and the doctors that the defendant has now stated that he is no longer within the parameters of incarceration, putting him outside of this forensic mental health team. And this is the evil that I say should be shut down. This whole entire forensic mental health team should be shut down. It should be disbanded and shut down completely. This is where every prisoner across the whole of New South Wales, regardless of what they're in there for, would face this team if they had a problem with being inside jail. 91. It is important to note that the defendant would be subject to the parameters of a CTO to manage his mental health issues, which can be renewed as many times as necessary. As well, the Commonwealth Recognizance Release Order in place until March 2022. These items have a role of greatly curtailing any risk that the defendant will commit an offence. And throughout this entire document, no one has defined what offences were committed, were planned to be committed. This is the unusual part here, in that these orders could be renewed over and over and over and over again to watch someone and keep someone under the thumb of this Fixated Persons Unit and this anti-terrorism squad in New South Wales for a perpetual amount of time, without even defining any offence that could have or would have been committed. No offence has been defined. No suspicion of any offences has been defined in any way, shape or form throughout this entire ordeal. Just his beliefs in a doctrine, his beliefs. His sole point comes down to, you believe in something? Oh, we need to correct you. You can't believe in something. 90. Whilst the bar at the preliminary hearing is a low one, there is still a requirement that the court is satisfied to a high degree of probability that the person poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. Section 24(7) of the Act requires the court to dismiss the application if the supporting documentation does not justify the making of an ESO. When the matters set out in Section 25(3) are considered, particularly noting the nature of the type of activity the defendant has actually engaged in, all there is comprises of a generalized risk of making offensive YouTube videos and or speculation about what other people might do when they see such material. This is working backwards now a very important clause to take observation of, in that there is no crime. The police just happen tanty that some YouTube videos were made that demonstrate that they're criminals. And all they've done is back up that claim by acting like the criminals they were pointed out to be. It's unfortunate, but it's true. And the amount of organisations listed in this document moving backwards so far already demonstrates the collusion by doctors and the police and possible ministers of these departments of state being named in these documents, and could be considered to be a conspiracy at law. It's a bit hard to deny when all the facts are on the table. And the Justice has done this on purpose. There is a way she has laid this document out that allows us to reflect back on what is a definite abuse by the state of New South Wales. And the state of New South Wales should be very embarrassed at this point, having the United Nations come a-knocking and be refused by these very corrections facilities that we're talking about here. 89. In respect of section 10(1)(a) generally, the United Kingdom of Australia does not support terrorism acts or violent extremism. It must be borne in mind that the United Kingdom of Australia is not a declared terrorist organisation. The court should have real reservations about making a finding that the defendant's conduct meets the statutory threshold